Often when we sue a debt collector in federal court, we are kind of questioned by either the debt collector or the defense lawyer, maybe the collection lawyer. They say, well, what's the basis to sue us? And we say, well, you sued my client in a collection case and said we owed money. Turned out we owed no money to the debt collector. That's what winning normally means when you are sued in a collection case and you win your case. And the debt collector put on your credit report that you owed all this money, and now you have a judge saying you do not owe any money. And so that's a pretty good basis to sue under the Fair Debt Collection Practices Act, which basically that law says don't do anything unfair and don't lie, don't deceive in any way. Well, I mean, saying you owe $5,000 when you really owe zero is pretty deceptive. Saying that on your credit report is deceptive. Suing you is deceptive. Well, is that fair? Is it fair to claim that you owe money when you owe zero to that debt collector? I think that's unfair. And I believe that the courts agree with us on that. Now, there are also state law issues, and we've talked about these in other videos, but the main one's called malicious prosecution. And that simply means when there's a lawsuit brought and there's no basis for that lawsuit. And we see that from time to time. We see companies that do this. We have one case now where our client was sued, they won their case, and then they're sued again. It's like, well, how can you sue somebody a second time when a judge has already said this person owes nothing to you? And you're like, I don't care about that. I'm going to sue them again. Maybe I'll get a judgment against them. Well, that's an extreme example, but what we often see is these debt buyers sue. They have no proof, no evidence, no intention of bringing a shred of evidence, no intention of bringing a witness. All these are really just shakedown lawsuits, just extortion really, to say, I'm going to sue you and hopefully you'll be so intimidated and scared that you'll write me a check because I'm not going to prove anything. And if in my practice where we are suing these debt collectors in federal court, if I showed up at trial in federal court and I said, Judge, I have no witness, I have not one single piece of evidence I can get admitted, the judge would just be beside him or herself. They're going, what are you doing? And I said, well, I was kind of hoping the debt collector, the defendant, wouldn't show up and then I could win. Well, that's the approach that is typically taken when they sue you. I think that that's malicious prosecution. Obviously, they disagree. And that's why we have judges, that's why we have courts, why we have jury trials. And so, to answer the question, what's the basis to sue a debt collector? And we haven't gotten into everything, but just keep it very simple. They lied, they did things that are unfair, and probably they sued without any basis for that. Now, if they show up and they have valid evidence and valid witnesses and admissible evidence, then that's probably not malicious prosecution. But when they show up with nothing and you do not owe the debt to that debt collector, now keep in mind, you might owe it to GE Capital or Capital One or Chase, but unless those people sued you, it doesn't really matter. What matters is, do you owe the debt to, let's say, Midland, LVNV, Asset Acceptance, Portfolio Recovery, Unify? Do you owe the debt to those guys? Because if you don't and they sued you, that's a problem, I think. So if you've experienced this in Alabama and you want to chat with us, 205-879-2447. My name is John Watts. My law partner's name is Stan Herring. You can also read more about this and contact us if you'd like through alabamaconsumer.com. And if you like this video, feel free to share it. Feel free to subscribe to our channel and you'll get more videos like this. Okay, thanks for taking time to watch this and you have a great day. Bye-bye.